All right, well, welcome everybody. Thanks for taking some time out of your Monday afternoon to spend some time talking about planning and zoning. My name is Ricky Hoffman. Just as sort of a brief introduction, I'm relatively new to the DNR. I started here in mid 2024. My background is in local government zoning administration. I spent the last 10 plus years prior to coming to the DNR in local government out on the West Coast. I did city and county zoning and planning for a number of years, and that's sort of what my background and training was in. I graduated from the University of Wisconsin River Falls in community land use planning, which seems like eons ago. But yeah, I'm thankful enough to be able to continue to do this in some capacity, and that's a little bit about my background. I'm joined by Dan Petrik, my colleague. Dan, you want to go ahead and introduce yourself?
Sure. I'm Dan Petrik, the Shoreland Program Manager at the DNR. I've been here doing this for about 13 years. Prior to that, I worked for 10 years as a consulting planner for cities and counties in Minnesota. And I have a planning degree from the University of Minnesota. And so I've been doing this a while. And that's who I am. So welcome.
Just some housekeeping things to start with. Here's a little overview of the agenda that we're going to be going over. This is going to be a 2-hour training. I'm not exactly sure what that's going to look like. This is our first time providing this training, so we may go short, may go long. Maybe we'll hit right on that 2-hour mark. But again, we're gonna cover things at a pretty conceptual, high level. We're going to talk about comprehensive planning a little bit, some zoning history, basics, the land use decision-making process, and we're going to talk about adopting and amending zoning ordinances, some key administrative roles that you as local zoning officials take on. And then we're going to end out on just a brief overview of DNR's land use programs. Just some housekeeping things. This course has some objectives that we've outlined here. Again, I'm just going to kind of reiterate, this is intended to be real high level for newer zoning staff. These are going to be real basic concepts. We really want to drive home the ideas of making solid and defensible land use decisions. We want to talk about those relationships between comprehensive planning and zoning. We want to learn a little bit about how our zoning programs work in relationship with our state agency partners like us here at the DNR. And I can't stress this enough that local zoning controls differ widely throughout the state, throughout the nation, in terms of very specific nuances of how zoning applies in your community or your organization. Please reach out to your legal counsel in terms of those questions. This is really intended to be high level. There's going to be a large diversity in how these concepts and ideas play out in individual organizations. So yeah, just wanted to provide that sort of qualifying to this training. And also, if you have a relatively decent amount of background in local zoning and planning, again, this is probably going to be fairly review for you. Okay, let's start with a little bit of housekeeping on the interactive portion of this presentation. So we're going to be using Slido as part of this. I'm going to drop a link in the chat. And then you should be able to see a QR code on your screen. If you're using like multiple screens on your computer, go ahead and you can click that link in the chat and open up Slido. Or if you're wanting to access it via a mobile device, go ahead and use your camera and use that QR code to open the link via your mobile device's camera. You should open up to a page that says there are no currently active polls or something close to that. You can just simply leave this page open throughout the duration of the training. This is where we will use some of interactive question slides. They'll pop up automatically. So you don't need to close out or reopen Slido. Just go ahead and leave it open on your mobile device or on your extra browser page on one of your screens, and it'll just automatically prompt you to participate when those slides come up. none of these are intended to be like a pass-fail component of the training. This is simply to provide interaction and demonstrate knowledge that the concepts that we're covering during this training. So if you have anxiety for tests and things like that, don't don't get anxious. This is not intended to be a testing component of this training, but rather just a way for us to interact with you. Yeah, I think that's all I wanted to mention. Am I missing anything on that, Dan? I think that covers. Yeah, so if you're having technical difficulties using Slido throughout this, we're probably not going to be able to work through those in real time. So if for some reason Slido isn't working for you, just go ahead and put your interactions or your answers in the chat. Happy to interact that way as well. We'll talk about raising, or we'll go through the process of raising your hand if you don't know how to do that in Teams here in a second. But again, yeah, like Dan said, this is intended to be fairly casual training. If folks have questions as we're going through some of these slides, feel free to throw questions in the chat or raise your hand, and we can kind of interact with those as we move throughout the presentation. We're going to start out with the comprehensive plan and just a basic overview of that. I see most people probably think, when they think of comprehensive plans, they think of the physical document, the comprehensive plan that your organization has likely adopted. But I see it as that, as well as just a concept, right, that applies generally in the planning process for a number of different things, right? It might be your comprehensive plan. It might be a subset plan of a comprehensive plan. It might be some other initiative that requires public input and community visioning for a strategic plan that the community is putting together. So just to kind of start off, let's use that hand raising feature. So if you're in this meeting, if you're at the top bar, I don't exactly know how this is looking for folks on the call, but if you're looking at your top bar of Teams there, you should have a selection to raise your hand. Go ahead and click that. I want to see how many people work in an organization that has an adopted comprehensive plan. Go ahead and use that hand raise feature. How many of you work in an organization where you know that you have an adopted comprehensive plan? Quite a few. Good to see that you have an awareness of that. Now, to unraise your hand, you basically click the same button. So for those who work closely on a day-to-day basis with the comprehensive plan, go ahead and keep your hand raised. So you can, if you don't work closely with your organization's comprehensive plan, go ahead and click it again to unraise your hand. And if you do work closely with your organization's comprehensive plan, go ahead and keep that hand raised. A little bit less, but quite a few people still. So this is going to be, for those people who have their hand raised right now, go ahead and lower those hands for lack of a better term. But for those people who work pretty closely with their comprehensive plan, this is going to be quite high level in review for you. I think for the most part, if you work that closely with your comprehensive plan, you're going to know these concepts pretty well. We're going to talk about comprehensive plans, but we're going to focus on how that then dovetails into zoning as an implementation tool of comprehensive plans. So what is a comprehensive plan, right? It's a, like I said, it's a concept, it's a document, it's essentially a process that utilizes stakeholder input, data, analysis to inform an outcome, right? And that outcome can be a variety of things. In terms of comprehensive plans, they have many different elements that cover a wide range of different topics that sort of get at objectives or strategic outcomes that address certain things that the community has prioritized. Let's talk about just the purpose, right? So from a core level, before we've even started the idea of formulating plans and formulating and adopting zoning ordinances, what's the purpose? Why do we do this? Here's a few different bullet points that we've provided that kind of hits the high levels of why we do this. What is the purpose of doing this? It's that idea of trying to achieve a common goal of achieving health, safety, welfare, other goals of the community, maybe impacting growth and development in the community, and then balancing those individual rights towards the common goal. We saw, a lot of these planning and zoning initiatives come forth in the 20th century, right? Kind of a surrounding around that industrial boom, housing boom, kind of in the mid to early 20th century. We saw a lot of need for regulating land use because of incompatible land uses that were coming about as part of the Industrial Revolution, and urban sprawl from immense amount of housing that was being developed around these times. And then we saw sort of a shift. We see those health, safety, and welfare types of controls still in our zoning codes today, but we as a society sort of started expanding that view of things, like considerations for natural resource protection, consideration for natural hazard mitigation, maintaining high value land protections for things like commercial, industrial, agricultural lands, and so on and so forth. So that's just kind of a broad overview of why we do what we do, why we plan and zone for these types of things. And again, I think I want to emphasize, I can't emphasize enough just how difficult this can be, right? Because there's a lot of opinions that come to the table when we talk about individual things like economic development, like housing production, like natural resource protection. And oftentimes, as planners, we're sort of the tip of the spear when it comes to having and holding and facilitating those conversations that sort of work into the planning process, and constantly trying to battle that balance between the common good and zoning regulations that implement that, and balancing that with private property rights. So how do the comprehensive plan and zoning ordinances relate, right? How do those sort of complement one another? Well, as I've sort of already alluded to, the comprehensive planning process is sort of that higher level visionary document that covers a lot of different things, more than just land use, right? Land use and zoning, right? It covers various different things like natural resources, transportation, housing, economic development, a number of different things. And so zoning is just sort of one component of that. And zoning can oftentimes be a very integral implementation tool of the comprehensive plan, but it isn't necessarily the only implementation measure of a comprehensive plan. I think the thing to mention here, and I'm going to bring this one on the screen as well, is just to recognize that the zoning code contains those specific regulations that implement the goals and objectives, right? So the comprehensive plan sort of lays out those goals and objectives. Zoning is not the only implementation measure, but it's certainly one of those more tangible implementation measures of achieving goals and objectives across a myriad of different elements, right? Again, it might be transportation related, it might be natural resource protection related, it might be economic development related. The zoning code can cover a wide range of goals and objectives in terms of how those are implemented. And just a note here at the bottom of the slide, zoning ordinances and decisions must be based on a reasonable and rational basis. And what that really means is, what can you tie the specific zoning ordinance back to as a reasonable and rational basis for implementing that? So when you supplement that with a comprehensive plan, what is the evidentiary information that's inside of that comprehensive plan that sort of is the impetus for applying a specific zoning ordinance, whether that's a natural hazard mitigation type of provision. So maybe it's a floodplain regulation, or maybe it's a natural resource protection. So we're going to talk about shoreland regulations. Maybe it's an economic development related zoning provision where you're protecting certain areas of your community for the highest and best use, whether that's related to commercial, industrial, or housing related provisions. But the point there is to make sure that those are being backed up by a rational basis of why that ordinance is being adopted and applied at a local level. This is an infographic that's intended to, and we've got a couple different graphics here that is intended to sort of encapsulate what the planning process looks like. It starts with a sort of future-oriented vision that's documented in that comprehensive plan. The comprehensive plan acts as sort of a roadmap for achieving the vision. It includes policies and strategies on a wide variety of topics, as mentioned previously. A completed comprehensive plan is useful in and of itself, but community engagement is really like a huge key to this whole process, right? It sort of informs the credibility of implementing the plan. I think a lot of people sort of lose vision on the fact that these plans are based on that data collection and based on that stakeholder input. And so planners, oftentimes being the zoning administrators, the sort of tip of the spear for that implementation tool of the comprehensive plan, are sort of held accountable for these provisions. But the larger picture here is to recognize that there was a great deal of stakeholder input that went into the comprehensive plan that then filtered its way into how these zoning ordinances are applied. And therefore, it's really what empowers you as a planner to tie yourself back to the comprehensive plan and say, well, wait a second, there's a rationale for why these local zoning controls are in place, right? This wasn't just made up on a whim. This isn't something that's just in the eye of the beholder as being the zoning administrator. There's purpose and objective that lie behind these zoning controls. And that's what this graphic's intended to kind of show, is that circle of planning as it relates to local zoning implementation to administration, and it's cyclical, right? And then also the idea, which is this last part here, of just other entities that have planning processes, whether it's a watershed plan or maybe a local public works department that has transportation initiatives and plans that might help inform that comprehensive planning process and provide information which would bring you back to reevaluation of a comp plan, right? Plans continue to be updated on different cycles. Different entities have their own requirements for updating plans. A good example of that is like a local natural hazard mitigation plan. I think those are typically on like a 5-year cycle, right? And a local jurisdiction may have an impetus to go back through this process of determining how that incorporates back into their community vision and the plan. And maybe there are updates to their zoning ordinance that sort of come out of that plan update process. Here's more of a linear, just another example of what that planning process might look like. I kind of want to go back to, again, recognizing that I think most people associate this with a tangible physical plan, but it's also just a concept that you can apply to lots of different things, whether maybe you're a local emergency manager that's working through a natural hazard mitigation plan update, or maybe you're a housing advocate that's working on a housing needs analysis, right? This is intended to be sort of a concept that can be applied and certainly malleable to what the needs are, right? Recognizing that this isn't some hard, fast equation for how all plan update and other strategic planning efforts have to follow, as if it's some hard, fast rule. But again, recognizing that there's stakeholder input, there's data collection and data analysis related to that, all is sort of a informational rationale for formulating these goals and objectives and ultimately implementing them. One of the things that I sort of wanted to talk about on this slide was just the idea of, as local planners, we're always expected to be sort of a jack of all trades and a master of none, right? Like, the biggest thing here is, in my opinion, in my experiences of being a local zoning official and planner, is knowing your stakeholders, right? Knowing the people that are the specialists in their respective field, getting to know those people and being that conduit to the planning process. That's what we're expected to be, right? Plugging people into the people that need to be informed and in the process to be able to inform that planning process. So again, community vision, I won't belabor this. I think it's not necessarily one point in the process as this previous slide shows. I think it's generally a concept that applies throughout various points in the process. Maybe it's a kickoff meeting at a beginning of a planning process. Maybe it's various goal setting sessions during an informal time before the planning process officially starts off. And it also can be involved in individual planning efforts that aren't even necessarily directly related to a comprehensive plan update. But generally, the idea here is thinking about what priorities and values are in the community, thinking about what that means for the following and remaining steps in the planning process, and also just recognizing what are the things that we're responsible for, right? I think sometimes those things are maybe sometimes overlooked, right? Recognizing that there's a responsibility for a certain level of infrastructure that's being provided, and looking at those things to think about those through the planning process and how they incorporate into various points in the planning process. Tying back to that stakeholder conversation, because I think that's an important one. Who, and go ahead and just throw these in the chat, who might be a stakeholder in your community? Just go ahead and throw maybe an idea or two of who might be some stakeholders in our communities. Lake associations, residential, local business. Yep, absolutely. School districts. Yep. Watershed districts. Yes. I can't think of a wrong answer, although I'm sure there may be some examples, but for the most part, yeah, and it's going to vary widely from jurisdiction to jurisdiction. These are all great answers. I also thought of things in preparation for this training, things like maybe our emergency services, economic development agencies, realtor associations, maybe public health officials. Yeah, awesome. Thank you for throwing those ideas in the chat. I think those are all great conversations to be had. Again, there's a component of this sort of related to this slide here, which is data collection. Data collection, we think of numbers and tables, right? But again, these are maybe our stakeholders bringing forth things that we didn't even know existed. I would use an example of my time in city government. We were working towards trying to put together a housing and unhoused needs assessment in our community. And one of the most invaluable resources that I had through the process was our local United Community Actions Network. The acronym is UCAN. They had a whole sector of their organization that was dedicated to an unhoused needs assessment. It was a mandate through state and federal government. I think it was maybe a HUD requirement at the federal level. And they had all sorts of data related to the unhoused population in our community that I worked in. And again, that whole idea of being a jack of all trades, master of none, this was a huge benefit for me to be able to tap into those folks and use them as a specialist in that field to inform planning process that we were going through. So data collection is certainly a big piece of that. Again, driving data to accurately represent the issue and providing a rational basis for what those objectives and outcomes are through the planning process. So we're going to talk a little bit about the other pieces of this planning process. Strategic analysis. I think you can kind of understand that these are things that are specific to certain objectives, right? Maybe they're buildable lands inventories, maybe they're transportation system plans, multimodal plans, natural hazard mitigation plans, but essentially using data, processing that data into more specific implementation measures to inform an outcome. Goal setting implementation, again, we talked about this being, for the purposes of this training, we're talking specifically about zoning, but we're also considering the fact that there are a lot of different implementation methods through a comprehensive planning process. These plans are generally have periodic updates to them. I think most are on a 5, 10, 20, maybe even 30-year cycle. I know in the metro area, there are other specific requirements for that outlined in law. And again, reiterating, this is kind of redundant, but again, there's a whole myriad of implementation tools that assist in implementing the comprehensive plan. Today, we're going to focus on zoning as well as subdivision ordinances a little bit. Oftentimes in our comprehensive planning documents, we'll have future land use maps that sort of inform what sort of zone districts are applied in certain areas of our community. Maybe those are through zoning reserves, right? If areas are intended to be zoned differently in the future, they address things like nonconformities, allowable zone changes if an applicant or the city is looking to legislatively change the zoning map. So be aware that these exist. They do have a role in informing zoning and future zoning. Okay, so if you got your Slido screens up, this is a moment in this we're going to interact. So you should have had a active poll pop up on your Slido screen. Go ahead and read through the question and select on which response you think is correct. Again, if your Slido's not working, go ahead and just drop it in the chat. What do you think is the correct answer? So which of the following concepts includes a process by which a local government unit can take certain steps to establish goals and objectives in the community? Okay, yeah, 96% on comprehensive planning. Yeah, I think zoning probably, well, honestly, all of these answers in some way or another takes steps towards achieving goals and objectives of the community. But the answer we were looking for was comprehensive planning. So 90% of you got that correct. All right, now we're going to go into a really brief zoning history and then the purpose. So what is zoning? At a core level, zoning is just simply taking parcel by parcel in your community, establishing zoning districts. Oftentimes they're going to look things like residential, industrial, commercial, and applying regulations to those zoning districts. That's usually done by adopting a zoning map like this one shown here. I think this might be the city of St. Paul's zoning map. And then enforcing a local permitting process associated with that zoning map. One of the often questions I get is, well, are zoning ordinances the same as laws? And the answer is yes. Yeah, zoning ordinances carry the very same legal weight as any other effective local ordinance within your community. A little bit of history, I'll kind of breeze through this, but generally it's commonly associated with that industrial revolution times. We can kind of trace it back to European and even before the industrialization over in Europe, and just some of those compatibility issues, life, health, safety type of issues that came up during the Industrial Revolution. In the United States, it's more specifically associated with some of those initial zoning adopters, such as areas like Los Angeles, San Francisco, New York, some of those early adopters in the early 1900s that were then sort of validated through the federal government's adoption of the Standardized State Zoning Enabling Act. States then adopted that and sort of delegated those responsibilities to local jurisdictions. And then the landmark case for zoning in the U.S. is that Village of Euclid versus Ambler Realty case that occurred back in 1926. That sort of upheld the local government's ability to apply reasonable zoning law. In Minnesota, we have a number of enabling statutes, depending on what type of local government unit you are. In counties, that's Statute 394, cities and townships, that's 462, and in that 7-county metro area, it's 473. Just a quick note about townships, they're considered cities under statutes, but if they do choose to take on zoning controls, they cannot be less restrictive than the county zoning ordinance. I guess what I want to say with this slide is in some cases, the states delegate that zoning authority to local jurisdictions, but in some cases, the state chose to retain that zoning authority in certain rules laid out in Minnesota rules. So for specifically the Shoreland and Floodplain programs, the state rules set minimum limits on regulatory requirements for local zoning codes. So this is unique to those programs outlined in rule. And typically, again, the local zoning codes must meet or exceed those regulatory standards. Minnesota's floodplain program is, again, one of those examples. Its purpose is to try to preserve those floodplain open space areas, mitigate risk, apply higher standards to new development to ensure safer, at less risk development. It's a very collaborative program, right? We at the state level work very closely with our local partners in the NFIP as well as our federal partners to introduce those mitigation measures, whether they're through a local zoning ordinance or through other flood risk reduction projects. I think this is where I'm handing it over to you, Dan.
Yep. So hello, everyone. The other major zoning program that you're mostly familiar with is the statewide Shoreland program. And I thought it'd be interesting to show you what the policy statement is for the Shoreland Management Act. These words should look familiar to everyone. It's in the interest of public health, safety, and welfare to, protect water quality, values of shorelands, habitat, and scenic values. So, this is a classic rationale for supporting the public interest in zoning, and the Minnesota Shoreland Act uses those words to substantiate zoning. So the two statutes that we're concerned with today in this is the floodplain protections and the shoreline protections. You can see the statutory authority for these. It's also interesting that these authorities are integrated into the enabling statutes for cities, townships, and counties. That we have integration of shoreline and floodplains into these enabling acts. There's also the Wild and Scenic Program, the Lower St. Croix Program, and the Mississippi Critical Corridor Area Program. Those are all integrated in slightly different and more complex ways. But the point is that in the state, the delegation and then the limits on that delegation are clearly spelled out in various city and county enabling statutes. Moving on to the next slide here, we're going to be talking about some specifics. Both zoning and subdivision ordinances are key methods for implementing the comp plan, as we've talked about. They're frequently implemented together, especially if you're working with a conventional subdivision that has to meet the minimum standards of the zoning code as well as the standards of the subdivision code. And then PUDs are often situations where you have to work with both of these together. They are often found as different subsections of your code or as a standalone element. Subdivision ordinances sometimes are very standalone and separate from everything else. And that might be for a reason or state law as it deals with subdivision regulations very differently and in different parts of the statute than zoning regulations. So that's all I wanted to say there. But I do want to quickly touch on subdivision ordinances. The key reason we have them is to regulate how land is subdivided and then recorded for sale so that land can be passed on in perpetuity in a safe and legally understood manner. And then secondly, subdivision ordinances exist to regulate the development of a lot of public improvements, public areas, trails, walkways, and parks. There's a park dedication fee requirement that cities and counties can use to charge fees to development to pay for these developments of parks. Of course, there's streets and street lighting and a lot of utilities. And of course, subdivision ordinances need to be implemented consistent with the zoning code. We're not going to come back to that much, but what we're going to do is focus more on the zoning ordinance. And as Ricky mentioned, these include both texts and maps. Maps should accurately and closely approximate zoning districts as written in the code. If there are conflicts, though, one needs to look to the text to resolve. Maps are inherently sort of inaccurate, even though we try our best to do that. One of the things, though, is when we're thinking about a zoning ordinance is the sections of it. And here are the typical sections you might find in a zoning ordinance. You have an administrative section, a general performance standards section, and then districts. And that's oftentimes where the heart of the ordinance is in terms of the sort of regulations that apply to each district. We also have a lot going on in the administration section. This is just an example of how some ordinances are organized. Everyone is absolutely different. These are very customized approaches, but you have some very broad general provisions that provide sort of the legal purpose and how an ordinance is to be used in the jurisdiction. Severability, abrogation, and greater restrictions are a lot of legalese phrases, but they're important. The severability clause is very important, that if a part of your ordinance is found to be illegal, it doesn't render the rest of the ordinance unenforceable. And the abrogation or greater restrictions talks about things such as if there's existing standards out there, you can't, like if you have covenants or easements, that they continue to exist. The ordinance can change and add restrictions to these things over time, but it doesn't repeal them. And this is also oftentimes where you'll find the more restrictive clause applies. And that's sort of a standard part of any zoning ordinance, is that there are inherently going to be some conflicts in a large document, and you need to always apply it with a more restrictive reading. You'll also find a lot of procedures for processing all types of applications, an explanation of roles of staff, advisory bodies, and elected officials, including how you appeal decisions, and of course, definitions. So there's a lot going on in the administration section, and if you're new to a city or county, it's important to maybe just sit down and read through a lot of this stuff, understand what it means, or talk to people and ask questions, because this is really where the rubber hits the road in terms of procedural matters and keeping your jurisdiction out of trouble. We're not going to delve into this, but a big part of any sort of zoning ordinance has general performance standards that oftentimes apply regardless of district. In some cases, some communities get into the weeds on some of these, and they might differ depending on districts, but oftentimes they are pretty standard practice across districts. One of the basic concepts is having a base or underlying zoning district. This is a very specific district. It's usually related to a residential, commercial, industrial, or mixed use sort of concept. The zoning district will describe what kind of uses are allowed, and they're usually described as they're either permitted, accessory, conditional, or temporary. We'll get into what that means in a little bit. But here is then also where you find your dimensional standards, what the district or what structure should look like, how should they be placed on lots, how much impervious surface can you have. You can even get into design standards for specific districts in terms of building material or roof pitch. So that's what a base zoning district is. Next, we have the overlay zoning district, which of course is what our Shoreland program is, or the Floodplain program is. These are districts that lay on top of a base district. Hopefully they're shown on your zoning map. They're not always, but that's where you need to rely on what your text says about these zoning districts, because the text will usually specify how you determine the physical parameters of where these districts exist. These overlay districts can be as complicated and comprehensive as a base zoning district, meaning that they can include dimensional standards or define how uses are allowed. But again, the whole most restrictive concept applies here. And this is where many new people get tripped up. They don't look closely at how standards might compare between a base district and an overlay zoning district. In some cases, especially if you have a shoreland district overlaid on an agricultural district, the agricultural district will have more restrictive standards for lot sizes or setbacks. So it's just important to know the relationship between the overlay district and the base zoning district. Just to repeat, these districts are typically used for environmental protection, or historic preservation, or economic development and aviation. These are the most common uses of an overlay district. Allowable uses is an important concept for procedurally how you approve certain uses. Permitted use is certainly something that's allowed by right. If you meet the standards for a permitted use, you get to do it. You still have to go through a review by staff in many situations, but if you meet the standards, you're approved, and if you don't meet the standards, you have to go back and modify your application so you can meet the stamp of approval. Those are usually done with what's called an administrative permit or zoning permit. The next type of allowable use is a conditional use, and we'll get into this in more detail in a bit, but these are uses that are permitted or allowed if it meets both general and specific conditions. If you have a large pole barn in a residential area, it's generally compatible if it meets some specific standards to make it fit into the neighborhood better than it would otherwise happen if there were no regulations. Conditional uses require a public hearing because they have the potential for impact in causing negative consequences, so the public gets an opportunity to come in and hear what's being proposed and comment on it. In a related matter, we have interim uses. They're very similar to conditional uses, but they're intended to be short-term, and they always have to have a termination, and that is usually on some particular date, a particular event, or when the zoning code no longer allows it. I'm not sure why, but we seem to be seeing communities adopting the use of interim uses that were previously used for conditional uses. So I'm not sure why that is. If any of you have any thoughts, we'd be interested for you to share those with us. And then just the last kind of concept in this category of stuff is just the accessory use or structure. These are things that are subordinate to the primary use. Just because they're accessory doesn't mean that they're always allowed. They could be a permitted use, but they could be a conditional or an interim use as well. It depends on the situation. In most cases, a lot of communities don't allow these before a primary use or structure is established. So we have two more questions for you. Feel free to go to your Slido webpage and answer these questions here. Okay, I think everyone's got this. We can move on to the next one. All right, thanks for playing our Slido game with us. Let's move on to the next part of this discussion here. What we want to do here is talk about various type of land use decisions that your communities can make and how you can do the best possible job in making those decisions that are transparent and also survive challenges, or hopefully you make them so good that nobody wants to challenge you. One of my favorite ways to talk about this is to use the pyramid of discretion from the League of Minnesota Cities. This outlines sort of the level of discretion communities have and the implications for that discretion when making decisions. So at the very bottom of this pyramid are these legislative decisions that Ricky's already talked about. This is where your county board or city council have an enormous amount of legislative authority to adopt a comp plan and a zoning code that complies with the comp plan that meets the needs of your community. These things can be modified from time to time, and they frequently are, but city councils and planning commissions have a large amount of authority to do that as long as they're not illegal with some state or federal or other jurisdictional law. At the other end of this pyramid, at the top, are building permits or site plan reviews. These are things that you have very little discretion. They either meet or they don't meet the permit requirements. And so if they meet the permit requirements, you have to approve it. And if it doesn't, then you can't until it's modified. But it's in the middle or yellow section of this pyramid where most trouble occurs. And these are areas like the conditional use permit, variances, and subdivisions or PUDs, where your zoning code actually provides you a fair amount of discretion to determine, if the project meets your standards. And here's where you need to be very careful about your application data, your ability to review it consistently against the standards in your ordinance, and how you translate that process for your boards of adjustments, your planning commissions, and your elected officials to act on that information. And so we're going to go through a few cases here to talk about these particular situations and opportunities in the process for maybe doing a better job. I do want to point out that the very center part of this is this area of quasi-judicial review. You may have heard that before, but this is where your planning commissions and Board of Adjustments are acting like judges. They are applying the facts that are presented through the application and in public hearings to your law. So you're not making law here, you're actually applying facts to your law. And that's where a lot of work is needed to keep your decision making free of challenges. All right, so let's just look at variances. Variances are simply the ability to depart from the strict enforcement of an ordinance on a specific property. It's for the ability to deviate from a dimensional standard, like a setback or a height standard. State law prohibits variances for uses. Therefore, you could not entertain an application to allow a commercial use, a gas station, say in a residential district. If a gas station, I think most people understand that, but just want to point it out. All variances, of course, require a public hearing, and they should be rare. If you are finding that you're doing a lot of variances, it's probably time to maybe revise your zoning code in a way to minimize variances. And that way you have a community involvement in this, and it's an acceptable change that everybody mostly is agreeing with. And then it ultimately saves everyone a lot of time and cost if it's not something that's really that important to the community. This example here is variance request from the bluff setback in the Shoreland area. You can see in this case, it's a difficult situation. Probably some variances needed is the level of deviation. And in this case, this community looked at this and said there was too much deviation from this proposed variance and is asking the applicant to reduce the size of their structure to minimize the impacts. And so this went through, a very thorough vetting process with very good staff reports that laid out the standards and the city's goals from a comp plan perspective in terms of protecting the bluff resources around a series of lakes. And so you can see that something probably is going to happen here, but in this case, they decided it was just too extreme of a departure, and therefore they wouldn't allow it. When it comes to reviewing and approving variances, the state provides variance criteria. It's called, most of us know it as practical difficulties, and that's the first 3 bullets on the screen. Statutory criteria also provides 2 other criteria which also need to be considered. This is the exact same criteria for both cities and counties, and has been around now for probably about 15, 20 years. There's no longer a concept of hardship in Minnesota. Hardship applied to, I think, cities at one point in time. I might have that incorrect, but it no longer is a statutory concept. So if you haven't updated your zoning ordinance for this new criteria, I would certainly urge you to do that. At a minimum, you'll have to have this criteria in your ordinance. You certainly can add additional criteria, but I would encourage you to make sure that it doesn't duplicate or sound similar to this criteria. Otherwise, it becomes very confusing and it clouds the situation in terms of providing solid findings of fact when you get to a decision. Next slide. The DNR has been offering variance training for quite a while. We did this back in the day with Government Training Services, or GTS, and we've evolved it over the years. You can find a recording of the most recent variance training at our website at this link, and at the end of this session, we have a variety of links for you as well. But if you haven't, I would encourage you to go to our Shoreland and Floodplain Training Center. You'll find a lot of recorded trainings. Just a slight tangent away from variances to nonconformities. And the reason I bring it up at this point in our training is because we see most variances for nonconforming structures. And so just to make it clear to everybody what we're talking about here, a nonconformity is just simply any use, lot, or structure that does not comply with current zoning standards. These are very common. Communities sometimes think it's the worst thing in the world to change an ordinance and then create nonconformities. But, that's progress, I guess. And, there's no kind of avoiding it. Nonconformities are simply a fact of life. And so it's just important to understand, though, that state law provides very strong protections for nonconformities. But in this case here on the screen, this particular community is modifying their use table to make Shoreland PUDs no longer an allowed conditional use in a variety of shoreland districts. And so you can see the strikeout, that's what they're doing here. And so any shoreland PUDs that were approved prior to this change become legal nonconformities, and they have state protections to continue, but you could not approve a commercial PUD in Shoreland going forward in this particular community. Just want to point out the difference between a legal or illegal nonconformity. A legal nonconformity is simply something that complied with the zoning code at the time they were established, and they do have a statutory right to continue. This contrasts with some sort of structure or lot that was created that did not comply. It was a violation at the time, it's just nobody knew about it. That is something that does not have legal protection to go forward, and you have your community is well within your right to require these properties to come into compliance with your current zoning code. The state protections essentially say that legal nonconformities may be continued through repair, replacement, restoration, maintenance, or improvement, but not expansion. Both the county and city enabling codes have the same language on this. However, Chapter 462 does go on to say that cities may by ordinance permit expansions of nonconformities. Now, I know a lot of counties also permit legal expansion of nonconformities by ordinance, but we have not found any authority in state statute to allow that. And so I would suggest if you look to your code to see if you're a county, if you have any sort of provision for that, to check with your legal counsel to see where that authority comes from. And we would certainly be interested in understanding that. So in any case, the expansion of legal nonconformities requires a variance in all cases unless you're a city that allows expansion under your ordinance. So, but a best practice here in any case is simply to define what these terms mean. The statute does not say what a repair, a replacement, restoration, or maintenance or improvement is. And there's these are very subjective terms, and many communities are challenged by trying to deal with the expansion or approving variances for these because they can't agree on what some of these terms mean. In this case, I would encourage you to look to build some good definitions for these terms, and it'll make your jobs easier when you have to deal with variances. And again, this is another topic where we have an existing training on, and again, just visit our training center and you can find training for nonconformities right there. Okay, moving on to conditional use permits. As we mentioned before, these are uses that are generally compatible with the underlying or base zoning district if certain conditions are met. These permits run with the land, so that they're really a permanent approval to use the property as it was approved with the permit. However, if the conditions are no longer complied with, the community can certainly revoke it or amend it if the permittee wants to amend it. Both those actions would require a public hearing to consider revocation or whatever, revocation, sorry, or amendment. In many cases, some communities still refer to conditional use permits as a special use permit. I believe they're essentially the same thing. With conditional use permits, there's always criteria for approving these. In every ordinance, there is what we call generic or general criteria, and these are pretty broad. You'll see phrases like this conditional use is acceptable if it's consistent with the policy of the comp plan, or compatible with existing uses, or won't impact transportation or utility infrastructure. But many conditional uses have specific criteria that also must be met. And this is an area sometimes where people new to planning miss this extra special permit criteria. So in the case of floodplains, if you needed conditional use for an alternative elevation method, such as putting a structure up on a filled stem wall or have it on top of a crawl space that allows flood waters to move through it, you would need a conditional use permit. And in that case, there is very specific criteria that you would have to meet in addition to your ordinance's general criteria. The 3 bullet points under this example here is just an example from a county in Minnesota. So it's important to look carefully in the special categories of land uses that your ordinance may contain to see if there are not only special requirements for approval, but does it have special criteria for the Planning Commission to evaluate. As long as we're talking about conditional uses, we need to talk about planned unit developments. This is a very special form of conditional use permits. Both city and county enabling statutes authorize planned unit developments as conditional uses developed under local controls. Most local governments nowadays do have what we refer to as a general PUD ordinance. These are ordinances that set the stage for a negotiated development. These are developments that allows deviation from your minimum standards in return for some desired amenities. These are very practical approaches for creating developments that meet a community's needs and a development's needs for, say, financial viability. They're practical because you can approve a wide variety of deviations in one fell swoop without having to go through a whole list of variances. They're very useful. They can be used in a variety of situations, both as a single use, like a housing development or some sort of commercial housing mixed use development. And many cities do the same thing through a rezoning. So instead of a conditional use permit, they might rezone a parcel of land to PUD as a new zoning district, and then the PUD development agreement lays out, the development standards for that particular new zoning district. But again, that rezoning is done as a part of a local control that you've been delegated by the state of Minnesota. Now, I've been emphasizing the word local control here because when we move on to the next slide and talk about the Shoreland PUD, which is also a conditional use permit, we run into a lot of confusion. And I have to apologize that the Shoreland PUD is just really a bad name. This is really a conditional use permit to allow greater density in shoreland areas subject to specific performance standards. This is not a PUD in the conventional sense where you can negotiate your best deal with the developer. So it's important to know that there is a difference here. We've had a number over the years, many difficult challenges, local governments who try to use their general PUD to deviate from the shoreline PUD standards. So I just want to point this out that the reason that local governments cannot use their PUD is because that would undermine state law with a local control. Our perspective is that local governments can only deviate from a state mandated regulatory program like the Shoreland program using a statutory means for doing so, which means using the state variance law and applying the state variance criteria. Just want to point that out. That's maybe a novel concept that maybe many of you haven't thought about. You may disagree with us on that, but that's how we approach this sort of situation when a local government wants to use a general PUD to deviate from the Shoreland PUD standards. As long as we're talking about subdivisions and PUDs, I also want to take a side trip here down the environmental review lane. Many local governments overlook the mandatory review thresholds for projects in shoreland. Just to recap, the reason the state has environmental review laws is so that projects with potential impacts can be evaluated and that information then presented to the public, including local decision makers. And hopefully the point is that you'll use this information to modify projects and reduce the impacts. And so for shoreland, there are some environmental assessment worksheet or EAW triggers for residential, campground, and resort developments. If you have at least 15 units in what is known as a sensitive shoreland, which is most commonly a natural environment lake shoreland, then you need to do an environmental assessment worksheet. If you have 25 units in a non-sensitive shoreland, which is mostly anything that's not in a natural environment shoreland, then if you have more than 25 units, then you need to do an EAW. There are different threshold triggers for environmental impact statements. I'm not going to get into the details of this. My point here is just to let you know that these standards do exist. And it's important that you require reviews if it falls under the mandatory review, and that this information is part of your evaluation, and that you do not permit a project until this review is completed. So every once in a while, we come across communities that have skipped this important step. And what that means is that usually you have to go backwards and sort of do this review and an internal permitting process over again. So please don't forget about environmental review. And then lastly here, we just want to talk about the important concept of conditions of approval. Nearly any project out there that you're looking at is going to have some sort of impact, and in most cases, some sort of conditions are applied. So you have a great deal of discretion to do this, but conditions have to be understood in that they have to be related to the impact and roughly proportional to the impact. There are two important Supreme Court decisions on this note. The first one was Nolan versus the California Coastal Commission, and that talked about the need for there to be a nexus or relationship between the impact and the required mitigation or condition of approval. And so in that case, the California Coastal Commission wanted to attach some sort of condition requiring public access to an impact related to a setback variance. And so that particular condition wasn't in any way related to the impact of the setback encroachment, and so it was not allowed. The other important Supreme Court case is called Dolan versus the City of Tigard. That's the idea where your mitigating conditions have to be roughly proportional. And the emphasis is on roughly. It's very difficult to quantify impacts, so you don't have to get all bound up in trying to figure out if you can quantify something. It just needs to be roughly proportional. And so, if you have a variance to allow a structure to be set closer to a lake by, say, 20 feet, a mitigating condition that requires the installation of a shoreline buffer that's 20 feet would be something, in our opinion, that would be related to and proportional to that sort of impact. Having structures closer to the water creates a runoff potential and erosion impacts closer to more sensitive shoreline areas. And we all know that vegetation is really helpful to prevent erosion, keeping soil in place, providing habitat and all that. So that would be an example of a condition that we think would meet the nexus test and be roughly proportional. So that's that. And then we're going to talk briefly about making good decisions, especially for these discretionary decisions like variances or conditional uses, even though it's important, even for a basic administrative permit decision. But here is where it's important that you have lots of documentation to support your decision, whether you approve or deny. And that starts with your application materials, the plans, checklists, studies, findings of fact, and minutes. One of the most important things is to make sure that you have a complete application. And it's important to think through what it's going to be like to review this application before you deem an application complete. They may have met, say, the letter of the law that you have in your ordinance, and somebody submits a plan, but maybe that plan doesn't show you where the bluff impact zone is, or where the shoreland setback is, or it's missing important information about vegetation. So you really have to look closely at your application materials to make sure that you can do a good job of evaluating it against the actual standards in your ordinance. We run into many situations where communities have accepted applications that are just insufficient to make a determination as to whether the ordinance standards have been met or not. So enough said there. Just a little bit about public hearings. Staff reports are really important for explaining what's going on, not only to your planning commission or board of adjustment, but for the interested public. And so the best staff reports kind of write to a broad audience to help them understand the essence of what's being discussed. And those sorts of reports are usually the most comprehensive and usually are very important in withstanding challenges to local decisions. The other thing I want to point out here is this idea of neutrality before decision making. It's very important that your members of your board of adjustment, your planning commission, your city council, your county board do not weigh in or make opinions about decisions before the public hearing. Yes, neutrality is important to keep this public process, have integrity, and for people to trust that it's working. I know that a lot of communities or members of these advisory boards have opinions, and they're entitled to them, but they need to keep them to themselves, but also as a public servant, be open to looking at the data and the facts that are presented at public hearings before they make a decision. The particular variance case that the DNR challenged, and we didn't go to court, the local government settled, but one of the problems with the local government was that some of the city council members had made a decision way before a public hearing that they were going to grant this variance because it was important to economic development. And that really weakened their case at the end of the day and is one of the reasons why they settled. So it's important for you to encourage your public officials to maintain this sense of neutrality. I've mentioned this a few times, the importance of decisions that withstand challenges. And so to do that and to stand up in court, your findings of fact, in a more simple terms, your detailed and rational explanation of why a decision was made needs to be very thorough, and it needs to be very clear about what the facts are and how they support a decision to deny or approve. And so in this case, you need to look at the legal criteria. Case of variances, we have statewide criteria plus criteria the local government might have. We have conditional use criteria. And so in all those cases, you need to explain and use the word because. The word because is a magic word when you do findings of fact. It's very important to put some facts together and say that the decision is supported or not because, and then explain thoroughly why or why not. It might sound easy to do, and in many cases it's very challenging to do, but I encourage staff to spend time thinking about this to try to help their planning commission or board of adjustments be thorough and thoughtful in doing this work. We have in our variance workshop or training, we have a lot of materials on how to find good findings or develop good findings. We have on our variance website a lot of template documents to help writing findings of fact. And so we're not going to get into that here, but again, I'd encourage you to look for those materials on our website. They might be very helpful for you and your community. Before we leave this subject, just want to look at a couple of findings and have you maybe raise your hand. Do you think this is a good finding, or is this sort of a poor finding? The idea that this proposed home site will have no adverse effects on the bluff. This looks like somebody is asking for a variance to build in the bluff. But because this bluff feature is stable and has never moved, the home is not going to have any adverse effects. So raise your hand if you think this is a good finding. Well, and I'm not seeing many people raising their hands. So I think you probably all know that this could definitely be improved in many ways. I think the first thing to think about here is that, what is the value or purpose of bluff standards? It's to keep development away from bluffs so they don't become unstable. So this sort of finding here is sort of undermines the essence of what the ordinance standards are supposed to be about. And then another one here, this is another finding. This time the finding is the project site during and after construction will have no erosion risk because the applicant has provided a detailed erosion control plan which will be implemented as a condition of approval and inspected at various times during construction. We're just going to give this away. This is our idea of a better finding. It could be used in a variety of applications because it gets at the essence of a good example. It uses the word because. It talks about very specific actions that the applicants can do, including at various times during construction. This is a very helpful finding and really could be used to defend a city or a county against a challenge that they didn't adequately protect against lake water quality or something like that. So that is pretty much where we are here. I have one last slide, and I know this is a sort of a complicated slide, but what I wanted to point out here are opportunities for improving on this discretionary decision-making process. And one of the most important things you can do if you aren't doing it now is having a pre-application meeting with your applicants. This is where you can ask questions, fine-tune an application, or even find alternatives. So if somebody's asking for a variance, you can maybe find an alternative that would either completely eliminate the need for a variance or reduce the level of deviation requested. And so this is a way to really understand what's going on and to make sure when they submit their application that they are indeed submitting a complete application. So you're not left guessing when you do your staff review about things that you don't see on the site plan or on the application itself. So somebody then submits an application, you go through the complete review process, and you start your staff review. Again, some of the ideas we've talked about here is to write your review for a general audience. As most of you know, your advisory board members and even your elected officials don't know a lot about land use and planning. Sometimes you have a lot of turnover, you have new people constantly coming to the table, and it's a very foreign language unless they've been involved in this activity for a long time. I know it's more work, but writing staff reports to help educate your audience, including the public, about the issues and what the actual regulations say. And sometimes that might mean translating them into plain language so that your Board of Adjustment, Planning Commission, or the public understand what's going on. Then you have sort of divergent tax for variance applications or conditional use permits. If it's a variance, of course, it goes to your Board of Adjustment, where they can deny or approve at a public hearing. At the same time, your Planning Commission has pretty much the same sort of approach for conditional use permits or subdivisions, also at a public hearing. One of the things I want to point out is that the Board of Adjustment of a county is the final decision maker, whereas in cities, they are advisory and recommend a decision on a variance to the City Council. The DNR weighs in at different places in this process. Oftentimes during the staff review phase, our area hydros will ask staff to share the planning report with them, or they will provide information to staff on how to understand certain water-related issues that might be pertinent to the decision. So we hope that you will look to your local area hydrologist for assistance in completing a staff report or sharing your staff report with them. When it comes to presenting information in time for the public hearing, the DNR often provides comments for variances, conditional use permits, or PUDs. We usually only weigh in or comment on a project where we think there's very significant negative impacts to shoreland or floodplain. In those cases, we will probably provide comments recommending denial, and we'll provide, hopefully, some very good evidence for why that should be denied. And if projects are approved under which we recommend denial and we think are very significant ones, we will sometimes appeal those decisions. So we are active in this world. It's pretty rare. We are pretty much involved only in projects where there's really significant environmental impact, or where we see a major error in sort of the application of the correct law. So any case, we hope that you will work closely with the DNR through these processes to minimize appeals, which delays all kinds of activities. So that's all I have here. We have one last question to round out this section. So take a look at this and let us know what you think.
Getting the correct answer. So it's kind of stated backwards. What is an example of a land use decision that does not apply discretion? So if we go back to that pyramid of discretion, I believe it was the very top. So the top of the triangle is that building permit or staff level permit, which wouldn't apply discretion. Okay, so we've been talking, Dan and I have been talking for over an hour and a half now, and we're coming to the close of our 2 hours. And so I'm going to kind of boogie through some of these next sections. So I apologize if I'm kind of running through stuff quickly here. The next section we're going to talk about is adopting and amending zoning ordinances. A lot of this stuff we've already kind of alluded to and discussed. You know, this adopting and amending zoning ordinances can be tied to the comprehensive planning process, like we talked about at the beginning. It might be initiated for other reasons, such as state and federal regulatory changes, or maybe it's just a voluntary change at a local level that a jurisdiction's looking to make changes to their local zoning ordinance. This is again a legislative authority. So if we talk about that pyramid of discretion, this would be at the bottom of it with comprehensive plan adoptions and zoning adoptions, zoning ordinance amendments. So significant amount of discretion related to this, again, limited by statute. We talked about this a little bit with those statutory requirements, not only for adopting and amending zoning ordinance related to those public hearings. Obviously, city councils, board of commissioners, town boards have those final authorities for adopting and amending ordinances. There's statutory requirements for holding a hearing, notifying of the public hearing, and again, circling back to that conversation of those unique sort of environmental related state programs. In this case, the DNR's programs, we have those minimum requirements for our shoreland and floodplain programs. So the DNR would have a certain level of engagement related to anything that impacts the changes to the local shoreline and floodplain ordinances. Rezoning, another sort of example in that same category. So if that's initiated by a PUD or just simply an initiated amendment to a local zoning map, would certainly be in that same category. Best practices, here's just a couple of, in our opinion, best practices for adopting and amending ordinances. Plain language, right? Think about it from the administrative. So when you think about this, maybe put your administration hat on and think about how the language that's being considered for adoption is going to actually apply in real time to a project, right? So to help your zoning administrators out, you're going to want to use plain, unambiguous language so that you're not having to interpret or apply discretion when it's not necessary. You're using terms consistently throughout the ordinance. You're not interchanging terms, especially when you're relying on definitions for some of those legal authorities. Avoid duplication, right? So if you have processes in certain sections of your ordinance that are intended to apply across different sections of a zoning ordinance, certainly limiting duplication and providing those internal citations would be preferable so that you're avoiding conflicts between different sections of your ordinance. The use of graphics, I'm sort of torn on. I support them, right? They're very useful in sort of providing a visual interpretation of some of these more complex concepts in our zoning ordinance. So you have that example of bluff impact zone shown on the right. I think the use of graphics can be helpful, but I will say when regulatory changes are made to your ordinance that impact those graphics, you need to be aware of that and ensure that those graphics are being updated along with the textual changes that might impact how those graphics are represented in your ordinance. And obviously also just think about, design for the capacity of your staff, right? Do you have the tools at an administrative level to appropriately administer what's being amended and considered in the ordinance? A lot of things on paper might seem tangible and meeting the objectives of the community, but if it's impractical or too complex to administer at a local level, that sort of hamstrings the ability to appropriately apply that ordinance. Program or ordinance adoption and amendment. So again, this is just going over something that's already been, I think Dan already discussed to a degree. We have those state law requirements in our rules that set forth requirements for adoption of ordinances, meeting the minimum requirements, whether that's in our floodplain rules or shoreland rules, our wild and scenic river, lower St. Croix or Mississippi River corridor critical area. The vast majority of those required ordinance adoptions have already occurred for the shoreland and river related programs. So amendments oftentimes that we see are largely voluntary or related to maybe annexations or things like that. For the floodplain side, we see ordinance amendments that are required for newly participating communities enrolling in the NFIP are required to have a floodplain ordinance that meets minimum state and federal standards, or if new mapping is being updated from FEMA, communities are required to adopt an updated floodplain ordinance. Again, reiterating the fact that DNR notification is required for these. DNR, will often comment on these if there are any issues with non-compliance with the program, and we'll usually work through an area hydro to discuss that and provide a discourse and communication on how that needs to be rectified to ensure that ordinances are being adopted in a way that's compliant with state and in the case of floodplain, the NFIP program, federal minimum requirements. We do have a shoreland model ordinance as well as a floodplain, which I'll show on the next page. There's a QR code on each that'll kind of take you to the landing page for those where those ordinances are provided on our website. We provide for both the shoreland and floodplain ordinances a version with commentary that's intended to provide a little bit more nuance to statutory provisions, citations, maybe interpretations of potential higher standards that we include in our versions. Those higher standards are typically highlighted in blue as optional language. We provide a version without commentary that's intended to be sort of plug and play for communities that want to consider model ordinance language. Both of these are intended to sort of meet the minimum regulatory standards on the shoreline side. Of course, that's the shoreline rules, and then on the floodplain side, that would be the state rules and minimum NFIP requirements. So again, you can use that QR code to navigate to either the shoreline or floodplain model ordinances. We periodically update. We're in the process of updating our floodplain model ordinance. We've did that in response to our most recent mapping update process with St. Louis County because we had some coastal floodplain implications there, and so we're in the process of getting those updated on our webpage. Again, this is feels like a very redundant slide. We've talked about this. We have notification requirements for land use actions in anticipation of a public hearing. Generally, that's going to be dependent upon the program. You can see the different program requirements here. We also have a requirement for notifications after local decisions have been rendered, and then on the right-hand side of the slide, a note about those ordinance amendment proposals and the requirement for 30-day review, notification and review prior to that local adoption hearing. The one thing I would mention with this slide is again, a lot of local ordinances take the shoreline and floodplain regulations and sort of organize them into their local zoning codes in a way that sort of matches their existing organizational structure of their zoning code. And sometimes that means that they're not a standalone ordinance like our models are laid out to be. So just recognize that in some cases, if you're making ordinance changes and they impact those shoreland or floodplain regulations, you still have a requirement to submit those notifications to the DNR. It just might not be as explicit because you're not, physically making a change in some cases to a shoreland or floodplain section. But that if the proposed changes impact the floodplain and shoreland regulations in any way, there's still that requirement to provide those notices. Here's just sort of an infographic of the review process. Generally, the DNRs becomes notified this. We do a review. If there's discourse or communication that needs to happen prior to the conditional approval, we'll sort of facilitate that, likely through your area hydro, or at the very least, the area hydro will be involved in that. We'll work towards rendering a conditional approval and then directing the local government unit to move forward with revisions required in that conditional approval, and then moving forward with that public hearing and adoption process. And then, of course, submitting, once local adoption has occurred, submitting those final approval materials back to the DNR for final approval. I've included the shoreline and floodplain emails at the bottom. For shoreline, you're generally working directly through your area hydro and copying that ordinance review DNR at state.mn.us email. And then on the floodplain side, you're working directly with the central office, and so submitting those to that floodplain email. Implementation flexibility, really just be aware that this exists with the Shoreland and MERCA programs. It's a complex process that requires sort of give and take on applying flexible standards. This is generally something that should be started well before a local adoption is being considered, and it is quite a long discourse with working through your area hydro and central office staff. Okay, we're going to do another Slido here. Which level of local government has final authority for adopting an amendment of zoning ordinances? It looks like most people got this one locked down. Yep, that's exactly the response we're looking for. City Council, Board of Commissioners, or town boards have that final authority on adopting and amending zoning ordinances. Okay, I'm going to run through some key administrative tasks here quick. We've already talked about accepting applications. I'm not going to reiterate this too much. Know that there's these deadlines laid out in statute for accepting and approving applications. And Minnesota Statute 15.99 lays those out for zoning applications, and Statute 462.358 lays out that for subdivision applications. So know that these exist, and if I can say anything, these go very quickly in my experience. So it's important to be thorough in that completeness review and accepting good, sound, complete applications before these clocks start to tick. Just a reiteration of something we've already talked about. Again, making sure that this is a very critical point in the review process. You want to make sure that you're being effective with that review process, ensuring that all of the application materials are meeting all of the applicable local criteria. You can use checklists, procedures, whatever it might be, forms to try to help you through this process to make sure that you're not scrambling at the back end when the clock is ticking. Another kind of redundant slide, again, just having a well-defined process, both in terms of the information that you're accepting, but making sure that you're reaching out to the appropriate internal and external agencies and staff people to make sure that those reviews are occurring, right? So if you have sewer, water, other public works, building, environmental staff, fire staff that have some aspect of review, ensuring that you have sort of procedures in place before you're accepting these applications to make sure that those are occurring where appropriate. Defining those processes are really important and are going to make your life much easier in the long run. Another Slido question here. What level of local government typically accepts and does completeness review for land use applications? Yep. Everybody's got this. I think this is this is too rudimentary for most of the people on this call, I think. No, this is good. I'm glad everybody understands these concepts. All right, we're going to kind of just reiterate at the very close out of this DNR's land use programs. You can see them on the screen there with the appropriate rules, references, or citations. The goal and structure of these are they're administered by local zoning ordinances. So we talked about this already previously in the presentation, that although these are state administered minimum standards through rule, they are still applied locally and administered locally at the zoning ordinance level. They contain state and federal minimum standards, and they all encapsulate some level of regulatory controls to mitigate loss, protect private property, enhance and protect water quality, and natural resource and habitat protection. That's generally the philosophy of all these regulations that are administered at our program level. Here's an infographic of the regulatory structure. Again, the authority comes down from statute through state rule. It's administered by the DNR through oversight, but again, it's the local zoning ordinances are how these rules are administered. Floodplain program, we've kind of hit this up. Again, here's just some examples of some regulatory examples of how this is administered, or the regulations associated with the program. The program, again, is related to the National Flood Insurance Program and is intended to meet those minimum requirements along with the state floodplain rules, and allows communities to participate within the NFIP and communities, folks in the community, to get that flood insurance that is made available to them through the NFIP.
I'll finish these up. So the Shoreland, Wild and Scenic River, Lower St. Croix River, and the Mississippi River Corridor Critical Area programs are all very similar. The Shoreland, of course, is statewide and is the most comprehensive, but they all essentially attempt to regulate these sorts of things that you see on your screen. The standards are slightly different for each, but they are essentially trying to do the same. The Shoreland program is the only one with a buffer. The other programs are all defined with legal descriptions in law. So just keep that in mind, that the Shoreland program with its buffer makes intuitive sense. The other programs, less so. You have to actually look at and see where the legal descriptions are to determine the boundaries for these. Next slide. The important concept for a lot of these programs, or all of them, frankly, is understand the ordinary high water level concept. This is a definition that's in the state law. It's essentially that place on the landscape where there's been enough time to leave evidence where the vegetation changes from predominantly aquatic to predominantly terrestrial. And so you can see on our graphic here, where that might be. And it's an important concept because it's a jurisdictional boundary. So above that boundary, local governments have jurisdiction through local planning and zoning and their shoreline ordinance to zone and control land use. Below that level, the DNR has jurisdiction for work in the water under the public water rules. But as the next slide will show you, the boundary isn't always easy to work with. We have a lot of activities, such as the installation of riprap or beaches or retaining walls or dirt moving, that really can occur above and below this line. And so it's a fuzzy line sometimes, even though it's a jurisdictional boundary. And so the point of this, though, is to work with the DNR anytime you're working with these sorts of activities to make sure that the activity not only complies with DNR regulations, but that they also comply with any land use regulations that you might have. Just lastly, I want to repeat notification requirements. The DNR, we need you to let us know when you're going to amend your ordinance, and that includes a rezoning. So if you're rezoning something to PUD or something else, we need to be notified of that so we can just review what you're proposing. We also need notifications for conditional uses, and again, that includes PUDs, as well as notifications for variances or plats, but only if it involves a variance. And then again, we have our notification deadlines for public hearings. And again, we need to see a notification within 10 days after you have rendered a decision. And then just lastly, to summarize, Your responsibilities under these programs are to adopt and administer ordinances. Hopefully you're educating and explaining to your customers about these programs. And that's one of the reasons we have a variety of trainings, so that you can explain to them how these things are administered or why they're being administered, for resource protections. And of course, you issue permits and are making decisions on deviations or conditional use permits, and overall enforcing your ordinance. And then lastly, notifying us, as we've already discussed. And just so you understand that the DNR, we're a large agency and we have different levels of involvement, but your local area hydrologist is your first point of contact. One of their main jobs with you is to manage and maintain relationships with you, to help support you in a variety of areas, including how to use water resources wisely, how to manage your way through any sort of public water permitting process, and to provide you with a variety of technical assistance in a lot of areas dealing with water. With regard to our land use programs, their priorities are to review and approve ordinances and amendments to any of our programs. They will comment on PUDs and variances if they rise to sort of a level of problematicness. And that's a subjective idea. We have a lot of discussions internally about what that is, but we do engage, as you know, from time to time in commenting on applications. And then just lastly, the central office, people like Ricky and me, provide technical assistance and training to you and our area hydrologists. We work to keep our model ordinances updated. We take feedback from local governments about things that are unclear, and we'll issue updates periodically to hopefully make things more clear. We're also here to help interpret rules of application for any of our regulatory programs. Some of them are quite old and really, unfortunately, difficult to understand, but that's our job, to help interpret those so that you can administer them and not wonder what you're supposed to do. And of course, we do coordinate both legislative and legal activities and periodically update the rules themselves. And so that is the end of our training today. We have a lot of resources for you, and hopefully...
I would note too, Dan, I didn't mention this at the beginning, but we'll send out a PDF of these slides, so folks can get access to these links and everything that was contained in here. At the same time, we'll send out probably a short little survey just about this. Again, this is our first time giving this presentation, so we want to try to continuously improve this moving forward.
So yeah, thank you everyone for sticking with us for 2 hours.
Yeah. Okay. Well, yeah, I think that concludes our presentation. Appreciate everybody spending some time with us this afternoon.